Okay, let's unpack this. We're doing a deep dive today into something pretty fundamental in law.
Mm,
When a crime happens, how does the law figure out who's really responsible and to what degree?
exactly. We're looking at the Philippine Revised Penal Code, the RPC.
Right, using that as our map to see this, well, this hierarchy of guilt, from the person actually doing the act to someone maybe just helping out later.
It's quite a layered system.
Hmm.
The law is very careful about differentiating culpability. It really depends on how involved someone was.
So you have the main categories.
Principals, accomplices, and accessories. Those are the big three.
But there's a catch right at the start, isn't there? Something about that structure not always applying.
That's right. It's a key distinction. That three-part division, it holds for grave and less grave felonies.
Okay.
But for light felonies, it changes.
Ah, right. For the minor stuff, accessories are just off the hook. They're not liable at all.
Correct. The thinking there is about proportionality and, frankly, judicial efficiency.
So the harm is just too small.
Basically, yes. The social disturbance is minimal. The state figures it's not worth chasing down someone who, say, helped hide a very minor stolen item after the fact.
It focuses resources on the main act if the crime itself is minor. Makes sense.
Yeah, the punishment needs to fit the overall impact.
Before we get to the principles, maybe quickly clarify the difference between the other two. Accomplice versus accessory, they sound similar.
They do, but the timing is the absolute key. An accomplice helps during the execution of the crime.
Okay, while it's happening.
Yes, maybe providing some minor help, but their part isn't absolutely essential for the crime to succeed.
Got it. And the accessory.
The accessory steps in after the crime is already completed.
Like hiding the body or the loot or helping the main person escape.
Exactly that. Their involvement is purely post-crime. Timing separates them cleanly.
Okay. Now, who can even be a criminal? The active subject, as the law calls it.
Uh-huh. And the law is crystal clear here. Only natural persons.
Meaning human beings. Flesh and blood.
Correct. Not corporations, not partnerships, not any kind of juridical entity.
That's huge, especially today with corporate crime. Why can't a company itself be the criminal?
It boils down to the concept of mens rea to the guilty mind.
Criminal intent. Or negligence.
Right. A corporation, being an artificial entity, legally lacks the capacity to form that willful purpose or intent. And practically, you can't imprison a building or a bank account.
So when a company is involved in a crime, like massive fraud,
The liability pierces the corporate veil, as they say. You go after the individuals within the corporation.
the directors, the officers, the employees who actually made the decisions or took the action.
Precisely. They're the ones with the minds capable of intent. That's the principle you see in cases like Ong.
But wait, don't companies get fined huge amounts? Special laws can impose penalties on the entity itself, right? Like tax laws or securities regulations.
Oh, absolutely. That's a crucial caveat. Special laws can impose monetary fines directly on the corporation.
But not jail time for the company itself.
Never imprisonment for the entity. That still falls on the individuals. And this is where you also see exceptions to another rule,
Which one?
the Montilla principle. Generally, just being an officer isn't enough. You need active participation.
You have to have done something specific.
Usually, yes. But some special laws, like the SSS law for Social Security violations, impose what's called strict liability,
Meaning?
meaning the managing head or directors can be held liable just by virtue of their position for certain violations, regardless of whether they personally knew or participated.
Wow. Okay. So your title alone can be enough under certain specific statutes.
It can be, yes. It's a
Yeah.
powerful exception.
All right, let's shift to the main players. Principles. Article 17 gives us three kinds.
First, the one who actually physically commits the act. Direct participation.
The person pulling the trigger, so to speak.
Exactly. Second, the one who induces someone else to commit it. The mastermind.
Forcing them or paying them.
Right. Induction. And third, someone whose cooperation is indispensable. Without their specific action, the crime couldn't happen.
Indispensable cooperation. Okay, let's use that island murder example you mentioned.
Sure. So A convinces B to kill C on a remote island.
A is the inducer, B is the direct participant, both principles.
Correct. Now D owns the only boat that can get to the island. D knows what B plans to do, but agrees to ferry B over anyway.
D didn't touch the victim, just provided the boat.
But without that boat trip, the murder, as planned, couldn't have happened. D's cooperation was indispensable.
So D is also a principal, just as liable as A and B.
Equally liable as a principal, yes, even though their actions look very different.
Now, what if A, B, and D all plan this together beforehand? Does that change things?
Now you're talking about conspiracy, and yes, it changes the liability significantly.
How so?
If conspiracy is proven, the rule is simple and severe. The act of one is the act of all.
Meaning everyone involved in the conspiracy is equally guilty of the crime committed, no matter how small their individual part.
Exactly. Liability becomes collective and equal. But, and this is a big but, proving conspiracy is tough.
You need solid evidence.
Beyond a reasonable doubt. It can't just be assumed. Mere knowledge that something might happen, or just being present, or staying silent, that's not enough.
You need proof they intentionally joined in, aiming for that common criminal goal.
Precisely. Intentional participation towards a shared illegal objective.
Which brings us to that dramatic case, People v. Ortiz and Zaza, the spear attack.
A very telling case. Ortiz was physically struggling with the victim. Then Zaza, who was also there, suddenly grabbed a nearby spear and fatally stabbed the victim.
It happened fast.
Very fast. Yeah. Just a few seconds between the struggle starting and the stabbing. The court looked closely at that timing.
And they found.
They acquitted Ortiz of the actual killing Zaza committed. They ruled that the sudden, spontaneous nature of Zaza's act showed no prior plan or agreement between them.
Wow, so no conspiracy proven.
No conspiracy, therefore, no collective guilt for the killing. Ortiz was liable for his own actions in the struggle, but not for Zaza's sudden, separate act of murder.
That really drives home the point, without that proven conspiracy.
Responsibility is individual. Each person answers only for the specific acts they committed. It's about proportional punishment.
So wrapping up, the key takeaways seem to be, liability really hinges on active participation, not just being there or holding a title, generally speaking.
Active involvement is key.
And that critical difference between a spontaneous act of violence and a pre-planned conspiracy determines whether guilt is seen as individual and proportional or collective and absolute.
You've got it. The presence or absence of that common design is often the deciding factor.
Okay, so that leads to a final thought, maybe something for you, the listener, to chew on.
Right. Given everything we've discussed, particularly the rule that only natural persons, only humans, can form criminal intent.
Yeah.
How effectively can the legal system really tackle wrongdoing that's deeply embedded within complex organizations? Think large corporations or sophisticated criminal enterprises. If the law primarily targets individuals, does it struggle to address systemic harm woven into the very structure of these powerful entities?
A challenging question indeed. Food for thought.